with the beautiful girl that I met made in Japan. The beauty of her face was beyond my wildest dreams.
이제 알아채 줄래 나의 마음속에 너를 향한 마음 그대 떠올려 줄래 우리 함께 했던 그 순간들을 이미 알고 있어 네 사랑을 너의 언어로 말해줘 사랑의 떨림을 속삭여줘
이렇게 만나니 반갑네요.
서툰 말이라도 괜찮아 너의 마음속을 내게 열어줄래
Good morning, Mr. Chong. Have a seat.
It's a long day. So I think me and my wife interested in settling down in this place.
It is a beautiful place for our new home. I understand it's Mrs. Chong's. Youngest in Crystal Garden is now ready.
Thank you. And what about the SPA agreement?
We have prepared the sales and purchase agreement. Everything is in order. So everything is on hand? Yes, you can check every facilities in pages, and you can sign. Both of you can sign at the bottom of the page and the end at the last pages. Yes.
Unbeknownst to the couple, the solicitors had not conducted a proper land search before preparing the SPA. On 2006, the couple moved into Crystal Garden and lived there for years without knowing that the land had already been charged to Bank Islam.
Hello, Mrs. Chong. Hello, Sarah. Have a seat. Thank you, Mrs. Chong. No problem. What brings you by?
I want to invite you to my sister's wedding on this Saturday. Be sure to come.
Congratulations. Where's the venue?
We rent a hall across the street. You know, the one with the empty land?
Oh, that hall. The land is arid if you ask me.
I couldn't agree more. Speaking of the land, do you know some of the land here are charged to the Bank Islam?
What do you mean?
The developer borrowed the money from the bank and used the land as collateral.
That can be right. Our lawyer would have informed us about it.
Maybe you should ask your lawyer about it.
Yeah, you're right. I'll ask my husband to give you a call.
Hello?
Hello, Julian. How are you doing?
Great, yeah. I heard our land is charged by Islam now.
Is that so? You write to the bank and ask for the verifications, okay?
Yeah, do that.
The solicitor requested a disclaimer letter from Bank Islam, yet no resolution followed. Julian then soon found out that the estate developer has collapsed and Bank Islam has initiated a winding up proceedings against the developer. From the PTG meeting, Mr. and Mrs. Chong has also found out that the land is charged to Bank Islam.
Can we see the land search you conducted before doing our SPA?
I'm sorry, we can't locate the documents, I think.
A legal document is to bring, just like that.
Yes.
The solicitor implied a search had been conducted, although no land search had ever been done in the first place. Appellant filed a complaint against the solicitor. The disciplinary committee later found the solicitor was negligent and recommend a reprimand and fine. On September 2014, appellant received a foreclosure threat.
What is it?
A formal notice on both.
Wait, how many thousand money people set over?
Yes, that would be correct.
Oh, property mediation.
Sure. Yes, that's stated on the letter. But we're going through this on the letter. That's unfortunate. Anyway, Bank Islam is exercising its right under the trust. The next time, Mrs. Chong, Mr. Chong.
What are we going to do?
We're doing that.
Mr. Chong, please state your full name and occupation for the record.
My name is Julian Chong SOOK. I'm the bank manager.
Do you recall purchasing a landed property in Crystal Garden back in April 2004?
Yes, I do. My wife and I bought a semi-day house from Mereka Mesra Senja Berhad.
Whom did you engage to handle the legal documentation and conveyancing for this transaction?
I approached the property lawyer of defendant to continue our agreement and do the SPA.
I direct your attention to the SPA dated 22 April 2004, specifically item 3 of the first schedule. What does it state under the column name of bank or financier?
As far as I remember, it was left entirely blank.
What did the bank column signify to you at the time of executing the agreement?
Based on our lawyer preparation of agreement, the property was uncovered and does not have any charges from the bank.
Did you eventually pay the full purchase price and move into the house?
Yes, we fully paid the house in 2004 and moved in 2006 when it was completed and lived there with our children ever since.
When did you first find out that something might be wrong with the land title?
In 2009, some of our neighbors said the land was actually charged to Bank Islam. They said that the letter charges or disclaimer was required.
What did you do upon hearing this?
I immediately contacted the defendant and they wrote a letter to Bank Islam but does not get any reply since. I trusted our lawyer to handle everything.
What happened next in 2011?
Rekam Mesra was wound up and we received a letter from BTG saying that owner without a disclaimer letter would have to pay a redemption sum.
Did you ask the defendant to show you the land research results they supposedly performed when drafting your SPA in 2004?
Yes, in January 2012, they contacted us and they said they couldn't locate the document.
Did you later discover the actual truth regarding that 2004 land search?
Yes, we found out they never actually done any land search before making us sign the SPA agreement.
When did Bank Islam take definitive legal steps against your actual home?
On September 2014, we received a formal letter from Bank Islam demanding we pay 900,000 ringgit by 31st October or our property may be auctioned off.
What was the impact of this foreclosure to you?
We were faced with probability of losing our home entirely due to 900,000 undisclosed liability. We also bear many financial risks like diminution of our property value and leading to this lawsuit where we demand 1.5 million ringgit in damages.
Mr. Chong, you testified earlier that you discovered your neighbor's property were encumbered as early as 2009, correct?
That's when we heard rumors from neighbors.
And you knew by November 2011 via a formal letter from the PTJ that landowners without letter of disclaimer were at risk of paying redemption sums. Am I right?
Yes, you did.
In fact, you were so aggrieved by the defendant's handling of your files that you lodged a formal complaint with the Advocates and Syndicated Disciplinary Board in May 2012. Am I right?
Yes, you did.
You will agree with me, by May 2012, you were fully aware of the defendant's alleged failures and error in your SPA.
Yes, we're aware there is misconduct and negligence, yes.
Right. Yet you only filed these serious suits against my clients in July 2015, that it is more than 11 years after the SPA was signed in 2004 and more than 6 years after you first discovered the encumbrances in 2009.
Yes, it was filed in 2015.
Mr. Chong, I put it to you that you sat on your rights. You knew of the alleged breach and the presence of the bank charge years prior, and your claim is completely out of line.
No, I disagree with that.
I put it to you that any loss you allegedly arise the moment you signed a float agreement in 2004 and not 2014.
I strongly disagree with that.
Mr. Chong, defense counsel pointed out that you knew about the bank charge issues in 2009 and 2011. Between 2004 and August 2014, did Bank Islam ever block you from living in your home?
No, we live without any disruption.
Before the formal letter dated 2 September 2014, had Bank Islam ever issued an absolute demand to auction away your specific property?
No, up with that letter, it was a stressful situation. But they're very concrete about not forcing in payment and affecting the house directly.
Then why did you wait until 2014 to initiate this court claim?
Because up until 2014, we didn't know whether Bank Islam gonna go forward with the charges or they're gonna take any action towards our property. It was until the letter demanding 900,000 where it becomes serious. It became a risk for our property and our life. We end up needing to sue them to save for ourselves.
Your Honor, defendant doesn't do his job quite well. Defendant failed to conduct a proper land search and falsely led the plaintiff to believe that the property was free from encumbrances. The plaintiff only discovered the truth years later and suffered actual damage when Bank Islam threatened foreclosure.
With respect, Your Honor, the plaintiff's argument completely ignored established legal limits. My client's role in preparing the sale and purchase agreement concluded back in 2004. The law is clear that any alleged breach or possession of detriments occurred the moment the agreement was executed, or at the very latest, when the full purchase price was paid at the same year.
The court finds the defendant were professionally negligent and breached the duty of care owed by the plaintiff, which, as a result of the breach, caused the plaintiff suffer loss and damage. Accordingly, the judgment is entered in favor of plaintiff. Defendant are ordered to pay the damages in the sum of Rm 1.5 million.
Your Honor, even if negligence occurred, the plaintiff's claim is barred by limitation under Section 6, Subsection 1, Subsection A, under of Limitation Act 1950.
Your Honor,
Objection, Your Honor. Mere knowledge of a risk does not amount to actual damage.
Overruled, defendant, you may proceed.
Thank you, Your Honor. As I was saying, the plaintiff knew the charge was in 2009, yet failed to file the lawsuit within times. Thus, the claim should be time-barred.
Having considered the submission of both parties, this court finds that the plaintiff's claim is time-barred by the Limitation Act 1953. The 6-year limitation period began to run in 2004. As the present action was commenced outside of the period, the claim is time-barred. The appeal is therefore allowed. The judgment of the High Court is set aside.
Your Honor, the Court of Appeal adds in law, the question is not when the plaintiff discovered the negligence, but when the actual damage occurred. The plaintiff's property was not threatened until Bank Islam sought to enforce the charge in 2014. Only then did the actual damage arise.
Your Honor, the plaintiff knew the charge way earlier when they were chatting with their neighbours years ago. Knowledge itself should be sufficient to start the limitation periods.
In action founded in tort, damage was an essential element, without which there is no complete and actionable claim. Time ran from when damage occurred and not when the negligent act or omission occurred. Hence, in a tortious claim arising from a negligently prepared agreement, the time period for purpose of limitation would run from the date of infringement of the claimant's right and caused by the impugned agreement and not from the date of the agreement itself. Thus, the appeal is allowed and the decision of the Court of Appeal is set aside. Consequently, the judgment of the High Court awarding 1.5 million ringgit to the plaintiff is restored.
All rise. Court is adjourned.
I just had to let you know you're